2311, Racing and Front Row Motorsports lost a significant court case on Thursday, potentially forcing them to compete as open teams for the duration of the 2025 season, and it would be a significant setback. May one of the teams involved quit the sport, or worse, be banned soon. On May 9th, the United States Court of Appeals, in Richmond, VA, heard arguments from the lead attorneys for both NASCAR and the race teams, as the sanctioning body sought to overturn the preliminary injunction granted to 2311 Racing and Front Row Motorsports in December of last year. The injunction permitted the two teams to compete with charters without being subject to the release, ability to sue NASCAR, outlined in the 2025 charter agreement. They criticized the deal for containing these stipulations, alleging they qualified as antitrust violations when combined with other circumstances. On Thursday, the United States Court of Appeals ruled in favor of NASCAR, overturning the injunction. This will not take effect for at least 2 weeks because the teams can request another hearing. Nonetheless, if it is upheld, both 2311 and FRM will be compelled to race as open teams without charters for the rest of the year. If the teams do not request a rehearing, the final judgment will take effect on June 26, 3 weeks from now. During last month's hearing, team attorney Jeffrey Kessler attempted to argue for irreparable harm, claiming that it is not economically viable to have to qualify each week. According to him, running as open teams, forced to qualify on speed each week, would be a huge financial burden, perhaps jeopardizing sponsor partnerships and driver contracts. Finally, it may harm their on-track performance while simultaneously denying them the benefits of the charter agreement, which their championship opponents continue to enjoy. It is worth noting that only one Cup race this year has sent cars home due to field size, the Daytona 500. The Coca-Cola 600 likewise had a full field, but no cars were sent home that day. Both 2311 and FRM have 3 charters apiece. Things become more convoluted when you consider that they used the courts and the now vacated injunction to purchase a charter each from the now defunct Stewart-Haas racing team, adding a third entry for 2025. During the hearing, the judges questioned Kessler on the merits of the injunction, believing there was no reason they should benefit from the 2025 charter agreement, while challenging NASCAR over its specifics, noting that this case is without precedent. This was referenced in Thursday's order as a rationale for the final conclusion, which stated that Kessler's antitrust theory is not supported by any case of which we are aware. The United States Court of Appeals also ruled that the teams failed to make a clear showing that they were likely to succeed in their case, and therefore the injunction was revoked. The trial date for the lawsuit is scheduled for December of this year. 2311 Racing and Front Row Motorsports have spoken out after the U.S. Court of Appeals for the Fourth Circuit vacated the preliminary injunction that awarded charter status to both teams. Jeffrey Kessler, the attorney for 2311 and Front Row, stated that they want to take the next stage in the trial in December. We are disappointed by today's ruling by the 4th District Court of Appeals and are reviewing the decision to determine our next steps, Kessler said, per Bob Pockris of Fox Sports. This ruling is based on a very narrow consideration of whether a release of claims in the charter agreements is anti-competitive and does not impact our chances of winning the trial scheduled for December 1st. We remain confident in our case and committed to racing for the entirety of this season as we continue our fight to create a fair and just economic system for stock car racing that is free of anti-competitive, monopolistic conduct. 2311 and Front Row will not lose their charter status immediately. The teams have 14 days to request that the case be heard by the full panel of judges at the Court of Appeals. The verdict may take effect as soon as 7 days after the appeals deadline. In accordance with the decision of this court, the district court injunctions entered December 18th, December 23rd, and December 26th, 2024 are hereby vacated, the court's order adds. This judgment shall take effect upon issuance of this court's mandate in accordance with FedR App P41. Judge Niemeyer's decision throws into doubt the case's merits on antitrust grounds. In entering a preliminary injunction in this case, the district court held that the plaintiffs were likely to succeed on the merits of their antitrust action against the National Association for Stock Car Auto Racing, LLC, NASCAR, and its CEO, James France, because NASCAR, as an alleged monopolist, required the plaintiffs, as a condition of doing business with them, to enter into a release for past conduct. Because that theory of antitrust law is not supported by any case of which we are aware, we conclude that it was not a likely basis for success on the merits and vacate the injunction. When the injunctions were obtained last year, 2311 Racing and Front Row Motorsports contended that the decision would keep the status quo. NASCAR claimed that it had changed the payment system for the 2025 season to accommodate a field of 32 charter teams rather than 36. The NASCAR lawsuit will proceed as planned, with a start date of December. The injunctions permitted 2311 and Front Row to compete for the two charters they held in 2024. However, it did allow them to individually purchase a charter from Stewart-Haas Racing. Without charters, the teams will be forced to participate as open entries, resulting in significant financial losses. The United States Court of Appeals appears to have objected to the mandatory portion of the injunctions. A prohibitory injunction, for example, alters the status quo rather than sustaining it. Even worse, the court determined that the team's antitrust allegations do not have a reasonable chance of success based on the facts of the case. In short, because we have found no support for the proposition that a business entity or person violates the antitrust laws by requiring a prospective participant to give a release for past conduct as a condition for doing business, we cannot conclude that the plaintiffs made a clear showing that they were likely to succeed on the merits of that theory. And without satisfaction of the likelihood of success element, the plaintiffs were not entitled to a preliminary injunction. We therefore conclude that the district court abused its discretion in entering the preliminary injunction that it did. This is all the more true in view of the heightened standard for issuing a mandatory preliminary injunction, and because the one here required two parties to engage in business that one party claims to be illegal. We express no view, however, on any aspect of the pending case beyond those stated herein with respect to the preliminary injunction. Accordingly, the injunctions of December 18th, December 23rd, and December 26th, 2024 are hereby vacated. The United States Court of Appeals did not believe that previous cases were cited in the lower court decision. In the cases where case law was used, the appeals court believed it was done wrongly. As a result, this will need to be addressed in the team's appeal. Should the verdict be implemented, it will have far-reaching consequences for the 2025 season. Losing charter fees could be a huge concern for 2311 and Front Row for the remainder of the NASCAR season. They have workers to pay, sponsorship contracts to maintain, and race vehicles to build. That requires money. This verdict would allow 2311 Racing and Front Row Motorsports to compete as open teams. They will have all 6 of their collective charters withdrawn. This will affect the team's charter fees. It might also violate the team's driver contracts and sponsorship agreements. I believe the most pressing topic right now is what will happen to the Stewart-Haas charters. What happens if the acquisition of those cars is reversed? The Haas factory team has declared that they do not want to and cannot accept 2 additional charters. They are currently a one-car enterprise. So, would NASCAR repossess them? Underperforming teams' charters may be forfeited based on their performance over the previous 3 years, if NASCAR so decides. Long story short, there is a significant financial hit, potential contract violations with drivers and sponsors, and a major question mark over the Stewart-Haas charters. We'll see whether an appeal swings things back in favor of 2311 and FRM, but NASCAR had a significant victory today. Moving ahead, this has implications for the entire Cup Series. Other teams will now receive a larger share of charter money, at least in principle. It remains to be seen how NASCAR will respond to today's decision. So, what do you think? Will 2311 and FRM win in the end? Or will they have to make huge changes in 3 weeks' time? Let me know your thoughts in the comments down below.